Hi, Z.
Hey.
Sorry, I had a little freak out there. Let me change my name
Okay, yeah,
because I
me too.
think I'm you.
I was like, what's going on? And I thought, oh, that's probably Carrie.
It's me. I don't know what I'm doing.
That's okay.
Oh my
I'm
gosh.
I'm pretty much winging it myself.
Okay.
So, I
I'm like,
noticed
oh
as
yeah, go ahead.
I noticed as soon as I opened it up, it said recording in progress. So Zoom is set to this.
I'm going on my fourth year. So about 4 years in, and really honored to be here today. For some of you who attended the Cal Cities New Law webinar, there's some of this stuff's going to be maybe getting a second dose of it, but I will tell you that we've added some new things for this presentation, including adding a couple more bills, as well as there's going to be a little bit more on some of the legal opinions that are pending out there. Um, uh, and also a snapshot of kind of what we've seen so far in 2025 as it pertains to the municipal clerk profession. One thing I'm staying on this slide here for folks who want to take a look. Our firm does pull together each year a 2024 every year a municipal law handbook. It should be now available on the CCAC website, QR code there and website for you to access that guide. Moving forward, I believe, Carrie, that starting at a date to be determined, all of our legislative content and updates are going to be available for our members, exclusively for our members. But for the here and now, folks can go to the QR code or website and access this year's or 2024's new law handbook. So a couple of things, here's a run of show of what we're going to be doing, but for, as we're going through these bills, a couple of things that you'll want to note. Number one, if you see that the bill that we've highlighted is an urgency measure, that means it took effect immediately with a 2/3 vote of the legislature. So it's already been enacted in law. Sunset date, meaning that it's a program that is going to be repealed on a date certain. So oftentimes we'll see this bill shall be repealed in January 1, 2026 or January 1, 2030. And so you'll keep an eye out for that. And then delayed, of course, just being a delayed implementation. So something that is fairly comprehensive, that may take a little bit more time, other than when a bill gets signed into law, and then in January saying, okay, we're going to have a effective date of 2026 or an effective date of June 1st, 2025 or something like that. So it's a delayed implementation for the program that's been adopted via law. So no, going backwards here. All right, so just jumping right in. The first measure that we're going to be discussing is AB 1785. This bill prohibits a state or local agency from publicly posting the home address, telephone number, or both the name and the APN number with the home address of any elected or appointed official. So, it seems pretty cut and dry. However, there is there might be a concern with this one, given that it might be difficult for a local agency to comply with. But I'll kick it to Carrie for the practice tip.
Thank you. So Diane Gladwell actually brought this concern to us, and we'd be interested in hearing if others have concerns about this bill. So previously, the public official's home address was prohibited from being posted online, but now it also includes the APN. What Diane had brought forward to us was that a lot of our agencies, including mine, use permitting software and other software that automatically posts information on our websites, and that it may be difficult to identify who those elected officials or appointed officials are, and prevent those from being posted on the website. So if your agency does use permitting software and you haven't already talked about this with your planning or building or development services department, make sure that they're aware of this of this requirement that it not be posted online. And please feel free to reach out to me if if you have other concerns, or maybe there's other things that we haven't thought of yet. We are, continuing to evaluate whether it's necessary to pursue some cleanup language on this bill so that, we're not getting in trouble by accidentally violating the requirement. So thanks, Dane.
Yeah, absolutely. And yeah, again, convey those concerns to Carrie in the legislative committee, because if there is this sort of groundswell where other agencies across the state are seeing this, we've got a great relationship with Assemblymember Pacheco. I don't, we were monitoring this bill, in my conversations that, it wasn't the intent to try to get local governments, sort of caught up with non-compliance. And so I would imagine that there's likely going to be an appetite for some cleanup language if this is in fact an issue that we're going to be facing with respect to compliance. All right, moving on to SB 1034 Searto. So something fairly, I guess, positive, if you will, in the Public Records Act. So this allows for a 14-day extension during a state of emergency declared by the governor. So of course, right now, very, very salient and what the things that are happening down in Southern California with the pretty devastating wildfires down there. But it does allow for a 14-day extension to comply with California Public Records Act cases, as we know, and unfortunately, we've got bad actors in every space, and this is one of those where we've seen folks take advantage of some pretty devastating situations where local agencies are now being hammered with these voluminous requests in a time when really it may not even be safe to enter a building or safe to occupy, or someone's lost their home or something like that. And so this one speaks to that. So provides a 14-day extension to the traditional Public Records Act timelines based on factors including the governor declaring a state of emergency in that area. And so then, it looks like, Megan, did you want to go over some of the considerations for this?
Sure. And I'm Megan McClurg, Assistant City Attorney for the City of Chula Vista, and I'm lucky enough to work with Carrie on a regular basis here in the city in the clerk's office. One suggestion, some practice tip we have would be, most of you probably already have template letters that you send out with automatic extension. A lot of times, typically it's the letter you send out just saying that you need more time to compile the records and review them. So one recommendation we have is to just pre-draft a template related to this specific legislation when there is a state of emergency. That way you have it ready and don't have to scramble to find it if the governor does declare that in your jurisdiction. One thing to note is you have to either have staffing shortages or the closure of facilities where the records are located in order to use this extension, so just be aware of that. Also, there is a carve out in the legislation for records related to the emergency, so also be aware of that and maybe consult your counsel in that case. Thanks, Dean.
Okay. Political Reform Act. AB 1170, the gift that keeps on giving. So this is one where, CCAC took a pretty pronounced role in this bill throughout the year, worked quite a bit with Assemblymember Valencia's office, FIFA staff, and the FPPC. So the intent behind this bill is really to convert all of the traditional paper filings to the standard electronic filings through the FPPC's website. We are still, in the process of engaging the FPPC and the author's office on potentially, even citing more, whether it be cleanup legislation or some assistance on implementation. But I really do want to give a special shout out to Carrie on this one. She has been working, in addition to her full-time job, it feels like a full-time job, engaging the FPPC on this. Ethan Nagler on my team as well, one of our associate lobbyists, has been working on this as well with with Carrie and the legislative committee, trying to get them to move a little bit further on this. I'm going to kick it to Carrie to talk a little bit more about what are some of the challenges that we're seeing and provide an update.
Thanks, Dane. So first, I know that there are a lot of feelings around AB 1170. So there was a webinar that the FPPC did for CCAC back in November. That's posted on CCAC's website. They've done a few more since then. So if you have not attended one, I'd encourage you to do that. There are a number of things that we had expressed concern over and that we've heard from the CCAC membership that are challenges related to this bill. One of them is related to the public postings. So the FPPC does not post all of the 87-200 filers on their website. They only post elected officials on their website. And so, you know, as Dane mentioned, we've been engaging on this one since early last year. And one of the things that we had brought up to them is that a lot of us are posting all of our filings online. And so by them not posting the appointed officials, which is, you know, the city manager, city attorney, planning commissioners, the public is really losing transparency. So that's one of our concerns that we're working towards. Another one is allowing our filers to create expanded statements. So my mayor also serves on another local body that he has to file for, and our 87-200 filers often have the most to disclose, and so they cannot do an expanded statement in FPPC to add those other positions. So they have to electronically file through FPPC, and what FPPC has told us is that then they have to print out their filing, manually add in their other positions, and then send it off to the other agencies that they have to file for. So that creates a big kind of a barrier for the filers to post, but also it creates a lot of inefficiency for the other agencies receiving those postings as well. We also want to make sure that we can communicate and our filers can communicate with the FPPC and receive timely responses. If they need a password, if they can't get into the system, if they don't know how to use the system, that's another thing that we've heard from our members and that we've experienced is that we want to make sure that they're able to respond to our filers just like we would. So some of us are still doing paper postings. City of Chula Vista has been doing electronic postings since electronic filings, sorry, since 2017. So all of our filers are used to us being able to log in and see their account and help them with their filing and help them submit it and help them reset their password. And I'm here in my office, so, you know, mayor and council or anybody can walk over to my office for help. And that's not the case anymore now that the filings are taken on by the FPPC, is that us as filing officers don't have the ability to help our filers as much as we used to. And then another concern that we've heard is filers being able to use their legal position title. So those of you with a town attorney probably know what I'm talking about. The FPPC has certain titles that they want everyone to use. Like, I know a lot of our filings in the past have gotten rejected because we spell council member as one word and they spell it as two words, and so our filings would be rejected. And so those are some of the issues that we're working through with the FPPC and continuing to work on, even though this bill has already gone into effect. I would highly recommend reaching out to your filers and letting them know that. I've put in the email that I sent to my filers so that they know that it's not me and there's really not much that I can do, and that they really should make sure that they're able to get in the system and that they're able to start their filing well in advance of the April 1st annual filing deadline. If yours are, most of them are April 1st. If yours is a different date, then, you know, you'll have to adjust that. But this is what I sent to them so that they're aware of what that change is and that it only applies to certain positions. So I know that moving from paper filings to electronic filings for those agencies is going to be a big jump. This was one of FPPC's top priority initiatives for 2024. So I don't think that there was any way that we could have gotten around coming to this point where the electronic filing is required. But I think that we can continue to mitigate some of these issues that are coming out of it to help us, to help our filers, and of course, to make sure everything is transparent for the public. So feel free to reach out to me on this one as well if you have other thoughts or if I didn't capture your concerns. Thanks, Dane.
Yeah, and just a couple quick observations too. Number one, they were open to considerable amendments, and they did take, actually, if you look at the introduced version of the bill versus what was signed into law, there were several amendments that were taken. We didn't take an official opposed position on the bill. Frankly, we're really looking for some of our partners at NetFile and others to express more concern, but it looks as though their concerns were mitigated. I would also say that we had conversations, I mean, I would say probably at least once a month, maybe even more frequently towards the end, and really secured the commitments of the FEPC to work with us on implementation. So far, that has not yet bear fruit. We're in the process now of more formally engaging the FEPC, and have enlisted the assembly members who authored the measure, his help in helping broker some of those conversations as well. And so more to come on this one, but it's certainly something that we're continuing to work on, not just quite a bit last year, but we're certainly looking to try and make some improvements moving forward. Okay, AB 2001 by Assemblymember Gallagher. This, amongst other things, this measure mandates that local agencies must post campaign finance documents within 72 hours of receipt, even for late filings. The bill also streamlines posting requirements to apply uniformly across all filing methods, so electronic, paper, email, or fax. And then it does clarify that some social media posts are exempt from specific disclosures. SB 1027 by Senator Menjivar. This one it requires, or I should say, it authorizes a campaign committee to redact bank account number on a copy of a statement of a organization filed with a local filing officer. You know, not a huge impact, but certainly just authorizes the campaign committee to do that. AB 2041. By Assemblymember Bonta. This one, again, we talked about this last time around, allows an elected candidate to use FEPC funds for a maximum of $10,000 to be spent on security. This is sort of a larger trend that what we've seen in the past with allowing the use of campaign funds to be used for non-direct campaign related expenses. And this is another one that we've seen that was passed just this year, had an urgency clause, so it was effective immediately upon signature. Moving on to governmental bodies and candidates. AB 2302 by Assemblymember Addis. This measure aimed to kind of clean up what we've seen in Assembly Bill 2449. So this is the remote meetings statute that's currently in law. More to come on that later when we talk about trends, because we are going to have another bite at the apple on that, but we'll get to that later. But to be more clear, what we're doing here is, or what the bill does, is to clarify how many times you can utilize the exemption in 2449. So the new limits on teleconferencing: 2 meetings per year for a body that meets once a month or less, 5 meetings per year for a body that meets regularly or twice per month, and 7 meetings for a body that meets 3 or more times per month. So just clarifying that in statute. AB 2904. This bill requires notice of a planning commission's hearing on a proposed zoning ordinance or amendment. If the proposed ordinance or amendment to a zoning ordinance affects the permitted uses of a real property, at least 20 days before the hearing. And so this one, again, this is sort of where our planning, our planning department, our clerks department sort of engage. We didn't necessarily engage in this bill, given that it had more to do in the land use and planning areas, but it does have implications on municipal clerks. So I'll let Carrie talk a little bit about that.
Thank you. I just wanted to mention, if you haven't already, talked to your planning or building development services department, make sure that they're aware of this new regulation. I was just speaking with the assistant director of ours yesterday about this, and she was saying it makes it really difficult because it went from 10 days to 20 days. Our publishing deadlines are every 7 days, so it doesn't really align up with anything. And it is going to be something that may take a little getting used to, and definitely some more advanced planning to make sure that the notices are going out 20 days ahead of time instead of 10 days ahead of time for these affected items. So just make sure that you talk to them if you haven't spoken with them already.
AB 2631 by Assemblymember Mike Fong. So this requires the FPPC, in consultation with the AG's office, to create, maintain, and make available local agency officials and ethics training courses. And so the bill makes free online ethics training courses currently provided and managed by the FPPC. However, I think that they're going to need additional funding to provide training for additional elected officials. So, it's those school board members and other things like that when this bill becomes effective in 2025. So look, we're going to be looking in the budget to see if there's going to be more funding for that. But with respect to our members, this is a tool that will assist with our ethics training. AB 2715 by Assemblymember Borner. This bill actually was sponsored by City of Carlsbad, who was one of our clients. And so we worked on this bill, not only in our capacity as CCAC's advocate, but also the sponsor of the bill on behalf of the City of Carlsbad. But it does allow a legislative body to hold a closed session with other law enforcement or security personnel to talk about critical threats in infrastructure with regards to IT and IT security. There was, you would think that it should be a sort of a no-brainer that we don't want to openly disclose our vulnerabilities and our critical infrastructure in an open session. But nonetheless, we were getting some pushback, and so wanted to make sure that we were clear in law that we can discuss these. Now, there was this big discussion about, actually procuring the contract and going with, perhaps a vendor or something like that. That is not something that can be done in closed session. This is simply allowing for that discussion to happen confidentially, so our local officials can make the best informed decision. So happy to get that one across the finish line. AB 2803 by Valencia. This prohibits campaign funds from being used to reimburse expenditures for attorney's fees and other costs in connection with criminal litigation if the litigation results in the conviction of the candidate, elected officer for a felony involving certain types of offenses. Not necessarily a major implication directly on municipal clerks, but it is a change in the law, and we wanted to quickly highlight that. For these next slides, I'm going to pass it over to Carrie and Megan. This is the fun stuff that they get to talk about on FPPC and Levine Act.
Thank you. So SB 1181, there's a companion bill that goes with it, SB 1243, that's on the coming slides here. So this is an update to the Levine Act. So you probably remember from previous, was that last year or the year before, Dan? All the years are running together now, where the Levine Act used to only apply to appointed officials. And it was a bill that kind of got slipped in at the very end of the session, changing it to apply to council members as well. And it's the pay-to-play rules where the council members, if they accept a certain amount of campaign contributions, and they're prohibited from participating in decisions that are related to that. And so these updates kind of add some clarity and change the rules a little bit. One of the main things that it does is it specifies that certain types of contracts are don't qualify or aren't required to adhere to the Levine Act requirements, or it wouldn't prevent an elected official from voting on them. Dane, if you want to go to the next slide. It also changes the contribution limit from $250 to $500. And next slide. This is the companion bill that I was speaking about, 1243, which is the one that changes the dollar amount limit. These two kind of go together, and they were required to pass in a certain order, and both of them had to pass. And if you go to the next slide, we'll talk about some practice tips for the Levine Act and the pay to play. I know when this first came out, a lot of us were talking on the listserv and to each other about how do we implement this? What are some things that you do to make sure that your council members are aware, or to, prevent any issues related to the Levine Act? Some of the things that we've done, and we'll show you examples of those in the coming slides, are an explanation on the agenda for applicable legislative bodies. So we have it for our city council and for our planning commission. We have an explanation of what the pay to play regulations are and how they apply. We identify each agenda item, whether or not the Levine Act or these pay to play regulations apply. We have a disclosure statement on our speaker slips. We have a standard disclosure form that we include for agreements and projects. And then those jurisdictions with elected city attorneys, which we're one of the lucky few, there aren't that many, but if you're on here, consult with your city attorney to determine what's applicable to them.
And then
Oh, go ahead, Megan.
Sorry, Carrie.
Yeah.
One thing I'll note is one of the new exclusions under these bills is the contracts between two government agencies, but just be aware that there's a definition in that statute of government agencies that only includes local and state agencies. So federal agencies are not carved out. So if you have a contract with a federal agency, the Levine Act arguably still applies. And then with your city attorney, if you are one of the few jurisdictions with an elected city attorney, even though they've carved out items where the city attorney doesn't have decision-making authority, your city attorney may still have an issue if for example, our charter gives the city attorney approval as to form. And so the question is that decision-making authority? So just if you have an elected city attorney, which probably isn't very many of you, if you do, just make sure you consult with your city attorney's office to see what their preference is as to how those items get routed.
Thanks, Megan. Dane, can you go back one slide? These are tiny, it's tiny print. We're going to post all of the materials online for you, but this is just an example of what we've done with our agenda description. So this is our description of the government code section regulations. We've decided in our agency to refer to it as government code section 84308, which is what it is. The term Levine Act is well known, I think, among staff, the clerk world and the attorney world, but it isn't necessarily known in the public. FPPC is also changing how they're referring to it. They're doing a lot of pay to play is the term that they're using, or this government code section or Levine Act. I've asked them what terminology they're going to land on so that we can all try and adhere to that, so that it's just more clear from the public agency to agency what it is, that we're all talking about the same thing. So there may be more coming out about that later on, I don't know, but you can see here the description that we have, and then I highlighted in blue how we identify on each item whether or not the regulations apply. So in our agency, our staff drafts the staff reports. They will typically mark it yes or no, or they'll ask for the attorney's assistance, and then they all go through the attorney's office for them to confirm that whether or not the regulations apply. That's where we stop. Is identifying which ones apply, and then it's really up to the council member or the person making the decision to determine, do they have someone who's contributed? Have they exceeded the applicable limits? You can go to the next slide, Dane. These are just the instructions that we put in the staff report for the staff on how to decide whether or not the Levine Act applies and what the changes are to the Levine Act for 2025. On the next slide is what we do for our speaker slip. So this obviously are just clips from our speaker slip, but it's that we provide space for people to name the officials that they've contributed to and what the amount was that they contributed. And then on the next slide, we have our Levine Act disclosure, which I'll turn over to Megan to talk about in a little bit more detail.
So this is just quickly a form that we attach to our agreements. We have template agreements or in contracts. So we attach this and have the party we're contracting with fill it out just to flag any potential Levine Act issues. And then one issue we've had, it can be attached as an exhibit or as a standalone document that we just keep in our files. When we have amendments to contracts, where when the contract was originally entered into, Levine Act didn't apply in this case. When we amend the contract, arguably the Levine Act does apply. So I just have staff get this filled out and we keep it in our file for our purposes because it really is just for internal tracking. There's no requirement that you attach it to an agreement. You can kind of decide in your agency as to what the appropriate use is of the form, but this is our example.
And if I can, one thing that I failed to include on that slide that just popped in my mind is I also provide the FPPC's handbook on the Levine Act to all of the candidates who come in and pull papers because it will apply to them. So I ensure that they have that and that the receipt that they sign says that they've received that so that they know going forward, you know, how it would impact them potentially as they're accepting campaign contributions. I also wanted to give a shout out to Nicole in Beaumont, Deanna in City of San Diego, Andrew in County of San Diego to come up with all of these materials. We kind of borrowed from everyone as clerks do. So I really appreciate receiving those resources.
Okay, so there are two Attorney General opinions that came out related to the Brown Act last year that I'll go over briefly. As a reminder, Attorney General opinions are not binding law, so a court doesn't have to follow it, but at the same time, it's considered highly persuasive to a court, especially when it comes to the Brown Act. So these are, we should take them seriously and consider them as likely to be upheld by a court. The first one relates to State of the City events. And this was a case where the mayor's State of the City address was delivered at a breakfast that was hosted by the Ventura Chamber of Commerce. And members of the public could attend, but they had to purchase a ticket in order to attend, which cost money. And then there was also no way to watch the State of the City address in real time. And the question was whether it was a meeting under the Brown Act if a majority of the council members of the body were there. And so the Attorney General decided that it was a Brown Act meeting, and you see there, same time, same location to hear and potentially discuss an item that was within that council's subject matter jurisdiction. One thing is they focus on the fact that it's the statute says hear, not just discuss. So even though they weren't going to actively discuss it like they would in a council meeting, they were still listening to it. And so that was part of the decision. They also said that the conference exception doesn't apply because it's just a single speech by a single official regarding this city. It's not a more generalized conference that has information that's applicable to the public in general. And then lastly, that the community meeting exception to the Brown Act doesn't apply because the event wasn't open to the public and could only be attended by purchasing that ticket. So our practice tip is just, our State of the City is a noticed meeting with an agenda and public comment. So be ready to notice your State of the City event based on this opinion if you don't currently, depending on the circumstances. The second case from the Attorney General is related to ADA accommodations. And this is, obviously the premise of the Brown Act is that meetings have to be open to the public. The ADA trumps any state law, but the Attorney General said that state law in this case influences and is relevant to how we interpret the ADA. And previously, the Attorney General had opined that remote participation was not a reasonable accommodation under the ADA because in-person attendance was essential to public meetings. And the Attorney General pointed out in this opinion that times have significantly changed and that post-COVID, the Brown Act does allow remote participation through those live streaming and participation software. So they said really it's changed, and because the Brown Act now allows people to participate remotely in certain circumstances, it would be a reasonable accommodation if someone has a qualifying disability to attend remotely. So their one caveat was that they would have to be able to use the two-way video and audio streaming in real time. And then they would have to disclose the identity of any adults present at that remote location. But it doesn't have to be open to the public like a old school teleconferencing remote participation. So just something to flag to, obviously you would talk to your attorney's office about the issues here, because there's a lot of issues involved in this. There's a lot of questions and unknowns about these type of things. For example, one just question right off the top of everyone's head was identifying adults present with you if you have a disability and the person present with you is a caretaker or someone that would disclose the disability. That's probably protected information. So this is kind of uncharted territory, and no one's quite certain how this will play out. So, but just something to keep in mind.
Just one thing to add, Megan. You know, I'm not an attorney, so I don't pretend to be one. But as an advocate here and engaging with a lot of the other local government advocates in this space, there was discussion about, okay, well, you know, should we try and advance a bill that aims to codify the Attorney General's opinions? And I think the general consensus is no. And I think, frankly, you know, there are reasons. I think chief among them are whenever local government tries to for, I guess, lack of a better term, play offense on issues like this, it tends to, you know, it may tend to kind of go the other direction. And so where we have the ability for there to be some ambiguity whereby we can have individual interpretations that actually allows more flexibility than having it very strict in statute. And so I know there's been some comments in the past about, well, we need to, you know, why aren't we codifying this in the law? And really, if there's a need to do it, if there becomes a need over time to do it, then it's certainly something we'll want to explore more with our membership and perhaps even take the lead on it. But I think for the here and now, we want to see, you know, how this all shakes out with respect to using this as guidance versus going down the legislative route to try to codify this in law.
I would absolutely agree with that. And I think there's concern in the city attorney community about a lot of unanswered questions related to this decision. For example, you have jurisdictions that don't do remote participation. They don't have the audiovisual software to enable that. It's not set up. So theoretically, you could say that that's kind of an undue burden under the ADA. In other words, it's such a great cost in order to make that accommodation that you're not responsible. But there's concern that, you know, especially with legislation, that there might be some requirement to make that accommodation, which may not be affordable for cities. There's also a concern that where does this extend to? This decision talks about members of the legislative body. Is there a possibility someone's going to then interpret that to mean members of the public requesting an accommodation? So just a lot of concern about how far this goes, what it means, and a desire almost kind of to walk back the existing attorney general opinion or elements of it, or clarify and limit it a lot of vagueness, I think, in implementation. So,
you know, I'm going slightly off script here, but I think this also leads to a sort of a larger conversation around, and we've tried to figure out how to tackle this exactly. We just haven't figured it out yet. But you know, when you talk about the extent of the Brown Act and remote participation, some agencies have just said, look, we're not doing this anymore because for their community, the cost does not outweigh the benefit. And not just you know, monetary costs, but you know, folks that do the quote, Zoom bombing, where folks come in and make just really horrific statements and kind of occupy the meetings and create sort of distractions in these meetings when we're trying to do the people's work. And so folks have just said, look, we're not going to do this anymore. And so it becomes this you start going down the rabbit hole of trying to require that every agency have open two-way teleconferencing for the public, and then you're not doing potentially what's best for your community. And another thing is, when we've tried seeing this legislation in the past, talking about remote meetings in general, there has been a push by some of the advocates that would require not just allowing, they don't, so what they want is they don't want local public officials to be able to participate remotely. They want anyone from the public, really anywhere around the world to participate in these meetings. And again, I think the spirit of the Brown Act, the spirit of local government is trying to engage directly with the members of your community, and not someone that may live in another state or another country trying to just stir the pot or create challenges in your community for either entertainment or other nefarious reasons. And so lot to unpack here on remote meetings, but we're going to keep charting through it best way we can. But thank you, Megan, for walking through these opinions.
Yeah, and I'll just add just one very quick final note, because I feel like we've been on this live for long enough. The ADA accommodation would not be subject to the meeting limits. So when we talked about that other legislation where they limited remote participation, that legislation actually talks about when it's an accommodation not otherwise covered by the ADA. So our interpretation of this opinion is that if someone has a qualifying disability and it is determined to be a reasonable accommodation, that there would be no limit on that member's ability to attend remotely. It would be outside of the scope of that legislation.
So moving on to sort of measure the kitchen sink section of the presentation, a little bit of everything in here that we couldn't necessarily fit into a specific category. But one of the bills that we discussed, it was in the local government omnibus bill from last year. Shout out Chino Hills for pushing their language in the omnibus bill. There were some challenges around digital signature attestation. I will never say that right. Attesting the validity of a signature, I'll just say that. And so one aspect, these omnibus bills are quite dense and have lots of areas in local government. So this is just one section of SB 1514, the local government omnibus bill. But talking about the testing of a digital signature. So got that language cleaned up and specified in law to provide guidance to local agencies on that. Another one, again, wanted to make quick mention of this, SB 399 WAHAB, employer communications. And so this is the trying to stop the captive audience meetings, which is something that really is more prolific in other states, and frankly, more so by private companies, essentially saying, okay, you need to attend this meeting and we're going to talk about, union busting, or we're going to talk about some other political, thing that the corporation believes in. I got to tell you, some of these ones, it felt like pushing a boulder uphill. We tried every way we could to try and get public sector exempted from this bill. At the very least, some acknowledgement that there are tons of protections in law already with respect to organizing and dissuading folks from organizing in a union. Where the big challenge, where the rubber meets the road, where clerks may need to just keep an eye on this and of course talk to your city attorney, is that will we be facing a situation whereby, because part of your job duty is to sit in those council meetings where politics and political ideology is discussed, would you, personally, you may not believe in some of the things that are being discussed, but that, you're in your city and you're doing your service, would there now be a claim against the city under SB 399? And this happens to have, really anyone that is supporting council staff or district council staff, anyone that has to be in those meetings to conduct a report, and they're sitting there waiting to present their item. and really just got no acknowledgement that this was even going to be an issue. And, you know, it's something that, again, hopefully it doesn't become an issue. Should it become an issue, I think it's right for us to revisit this piece of legislation and really make that clarity. But did want to flag this one for the members here. AB 453. I said SB because Cervantes was an assembly member last year. She is now a senator this year. So this was then Assembly Member Cervantes, who is now state senator out of Riverside County. But this bill just says that when you're hosting district-based election hearings, that you have to have it at the set start time. So this is similar to when you're doing when you're doing redistricting, they're aligning the laws with districting and redistricting, that if you're going to have part of your open meetings to do those, to hold those hearings, that you have to have it at a set agenda time, and that needs to be properly noticed in accordance with the Brown Act. Yeah, time certain for the agenda versus, you know, having folks wait, you know, a super long time or something like that. AB 1784 by Assemblymember Pellerin. This is, I kind of call this the Vince Fong bill. And so this is in response to then Assemblymember Vince Fong, now Congressmember Vince Fong out of the sort of Bakersfield, Kern County area, who sought to run for that congressional seat while at the same time was still on the primary ballot as an assembly member. He filed his paperwork, was able to be on the ballot, so was actually on the ballot both as an assembly member and as a Congress member, and you know, lo and behold, he got elected to both. And so this bill aims to just clarify that law and codify the court's decision. It also made clarifying statements about an office, prohibiting the nomination papers at a party affiliation office. And so that was one thing that it did, that it also cleaned up the law on that as well. AB 3197 by Assemblymember Lackey. This one was sponsored by the LA County Board of Supervisors, but it aims to just really standardize candidate statements throughout the entire county, given there's so many jurisdictions in LA. It stands to reason why it was sponsored by the LA County Board of Supervisors, but I will kick it to Carrie and Megan to talk practice tips on this.
Thank you. So I've put the election code sections in here. The code section that changed regarding the standardized forms is elections code section 100. It applies if the county elections official is the one verifying the signatures on an initiative, referendum, recall, nomination paper, or other petition that has to be signed by voters. So the county elections official can develop a standard form that's required then to be used by our agencies. And then the second one is related to the electronic distribution of candidate statements. That one's in Elections Code Section 13307. And that one is the county can decide about an electronic statement that's in addition to the candidate statement that's printed and mailed to the voters. So you might reach out to your ROV in advance of your next election if you do elections to see if the standardized petition forms will be required and if they will be allowing electronic candidate statements. Mine does not allow electronic candidate statements, and they're running a special election right now for the county. So they haven't replied to me yet about the standardized forms and if they plan to implement standardized forms. But of course, you'd want to be aware of that well in advance because sometimes, you know, referendum, recall, they can come in and it's important for you to know. So just make sure that you reach out and talk to your ROV so that you know in advance if those are going to be changing for your agency.
Harry?
Thanks, Dane. Yes.
So is every county making their own form? Because our ROV in the last election was trying to get us all to use some standardized form from the Secretary of State, but it was a form that complied with elections law for districts, but not for cities. There's some differences between those two. And I'm concerned they're gonna try to give us the form that is for districts again.
So the bill allows the county elections official to require the use of standardized forms. I see Mark Newmanville has posted in the chat as well that they just got the forms from their ROV and had to make a lot of changes to them. So it's potentially they could require it. I would check with your city attorney and work with your ROV to mitigate any of those changes. That is something too that CCAC can look into. You know, maybe some cleanup language or something along those lines that would help ensure that they meet the needs of each agency as well.
We have a good relationship with the Casio, the county election clerks, and so if there is a need here where we're not able to solve it locally, we can always try and work with them in a collaborative way to provide some clarity around that if need be. Okay, moving to AB 2582. This bill, as of January 1, 2027, so that delayed implementation date, repeals the requirements for an elections official to preserve the list of new resident voters voting in accordance with these provisions for the next 22 months. And so I just wanted to confirm, Carrie, anything here worth noting? I know this is more of a elections. Okay. I just cover that quickly. These last ones here are just really more FYIs. I don't know if there's a ton of applicability here. I guess elections intimidation is something we want to shine a light on, but the bill prohibits intimidation, threats, or coercion related to an elections activities. You would think again that in California in particular, this, since we don't have the open carry, and we're not an open carry state, but openly carrying firearms in your elections activity is presumed intimidation unless proven otherwise. And so you can certainly, folks are carrying around firearms around an election line definitely should be against the law. Could definitely be perceived as intimidation in this state. So want to make sure folks are safe and that folks who are trying to intimidate elections can't. Actually, the note on this one should be, I probably should have just removed the slide because the courts have already upheld that this bill does not apply, or that it was held, from my understanding, that the courts have already ruled in this case. But this is the the Defending Democracy Deepfake Deception Act of 2024. And so this is really trying to curb the ability of AI to sort of regenerate or use deception in their social media. This one was facing litigation, as was deceptive media and advertisements. But all of these have, I don't know if 2839 has been fully adjudicated yet. But again, this is, I think, shines a brighter light on a trend that we're going to be seeing with the emergence of AI, with the emergence of deepfakes, and all of the legislation that we're seeing around how do we ensure that we're not, deceiving the voters. Stick to your those paper mailers that folks are getting. But when you start seeing your social media feed and targeted advertisements, it certainly raises the bar of things that we need to watch out for with elections deception. AB 3184. Also an urgency clause. This is so this was already in law for, I believe it took effect for this election that was just carried out, but it requires county elections officials to provide a unified online form that serves two purposes. Basically allows voters to verify their signature on a vote by mail ballot, and it allows voters to identify themselves if they forgot to sign their ballot envelopes. So there are a couple of considerations here. And so this really talks about the background of why the bill, why there was an issue. So there was about 60,000 rejected ballots. So they want to make a uniform date when counties can certify elections, and voters may not have a date certain by which they make the correction and could inadvertently miss the deadline. And so 3184 provides voters with that certainty if they are notified of signature issues moving forward, ensuring that everyone is operating on a level playing field. Okay, moving forward. So we've had, luckily, Assemblymember Gail Pellerin remains the chair of the Assembly Elections Committee. She's a former county ROV. She was the president of KCO in 2010 to 2012. Really is, our firm, of course, has a good relationship with her, as does a lot of the members of CCAC. She's fantastic, and is always someone that we can have, an open and honest conversation with. And what I think is really great is when we're talking about some of the nuances in the profession, she just intuitively understands it, which is certainly a benefit for our membership. There was actually a change in the chair from the last time we did a version of this presentation. So the Senate Pro Tem Mike McGuire made really wholesale changes in the committee makeup. So now State Senator Sabrina Cervantes is now the chair of the Senate Elections Committee. She's authored several measures, including mandated translation services. She authored the bill that created the redistricting commission for Riverside County and other related measures. And so she's taken, although she's been a member on the Assembly Elections Committee for some time, when she was an Assembly member, she was never the chair, but she's taken interest in introducing bills around language access and ease of voting for a long time. And so I anticipate her, doing a lot of things in the next couple of years as chair of the committee. So from an update perspective, we have the legislature came back on January 6th. Really, the bulk of what we've been seeing has been related in response to the wildfires, and so everything that was originally kind of set to go into motion has really been put on hold as the devastation and recovery down there is really taking up a lot of the everyone's attention. But I will say, what we're already seeing so far is, bills that touch on the California Public Records Act, Brown Act, posting requirements. We're seeing, there are 2 Brown Act bills that will be introduced this year. One of them has already been introduced. This is AB 259 from Assemblymember Blanca Rubio. This is an amendment to her AB 2449. Those provisions set to expire at the end or January 1, 2026. And so this just aims to repeal that sunset date, making that law permanent. CSAC is also running a measure. This is it's a reintroduction of what we saw last year of AB 817. And so we have, I think it's too early yet to comment on who the author is, but we have secured a senator who sits on the Senate Local Government Committee. That bill, AB 817, failed in Senate Local Government last year. So we have a member of the Senate Local Government Committee who is looking to really kind of pick up the ball and run with it. I was really passionate about this issue, but AB 817, for those who don't recall, is the bill that defines those subsidiary bodies of the Brown Act, so those non-decision-making bodies, allowing them to fully participate remotely without posting physical location and making their location available to the public. And so this is something that we're trying to kind of distinguish if you are a full council, if you are a planning commission, if you are a body that is making a taking final regulatory or legislative action, this would not apply. It is those appointed bodies that we all know that folks are on councils are a part of. The aim here is really to try and diversify and engage and increase civic participation. We know that, I know, talking to many clerks across the state, they have a very, very difficult time trying to fill a lot of the appointments for these boards and commissions. And so we're hoping that that should this measure be enacted, that it will help open up the candidate pool of folks who may want to engage. So far, we still are only tracking 10 bills for CCAC, but don't worry, there will be probably about 2,000 more bills introduced between now and February 21st that myself and our team will go through and as we did last year, divide by subject category and start tagging those bills, running them through the legislative committee to determine what positions we should be taking in accordance with the adopted legislative platform. And so, as I said, February 21st, last day for the legislature to introduce bills. We're seeing June 6th is the House of Origin deadline, meaning all bills that were introduced in the Assembly have to pass over to the Senate. All bills in the Senate have to pass over to the Assembly, or else they are dead for the year. September 12th is the last day for the legislature to pass bills, and October 12th is the last day for the governor to sign or veto bills in this first year of the 2-year session. And with that, plenty of time to take questions, and thank you so much for giving us the time.
If we
Thank you.
did want to put in like some suggestions for elections code cleanup, how would we go about that? Send it to Carrie or send it to Dane, or
There's a couple of options. So on CCAC's website, if you go under news and updates, there's a legislative updates page. There's a legislative proposal form on there that you can complete and submit to us that describes, what the sections are, what you're looking for, what you have in mind. So that's the best way to submit it to us, because then, we have more information, but you're always welcome to reach out to me. And I'd be happy to work with you as well. Thank you for that. If you have questions, feel free to raise your hand. You're welcome to unmute yourself or drop your questions in the chat. We're trying to answer questions as we went along. But if we didn't get to yours, drop it in. Let me see. Deanna is asking, are we tracking any bills related to records management as it relates to AI or changes in retention? Dane or Ethan, have you seen any of those start coming through yet?
Ethan, he's my first line of defense on introduced bills right now.
I'm checking right now. Hi, everyone. There have been a couple AI related bills, but there's still spot bills as of now, which means that there's very little in them. They're what's called spot bills or intent bills, where the legislature says we want to do a bill on this subject, and we'll find out later, over the next couple of months what those bills will be exactly, but no, nothing specific yet.
And I'll add too that the PowerPoint presentation, I can't tell exactly how many slides we got to, but there are 86 slides in the presentation. We've saved you all from taking a lunchtime nap. Maybe we should have kept going so you could take a nap. But there are a lot of bills that we didn't cover, including a few on AI. They weren't super relevant to clerks, but they are things that you may want to be aware of. So once we post all of the materials, I'd encourage you to download the presentation and go through those additional bills. But certainly as we see bills that would affect retention and things that would affect the municipal clerk profession, we definitely want to make sure that we are tracking them. If you become aware of things, feel free to reach out to me, and I'll be happy to make sure that we have those tracked.
For Bill AB 2904, the zoning ordinance notice, when did that one go into effect?
I believe that went into effect January 1st. Dane?
Correct.
January 1st? Okay, thank you.
So the materials and the recording will be posted on the legislative updates page on CCAC's website. I see someone asking about that. So let me drop that in the chat here. Give us a couple of days because we'll need to finalize everything and get it posted, but hopefully by the end of the week, we should have that all posted and available for you. So I just dropped the link to that in the chat.
Anne Marie, do you have your hand raised? I
Yes,
don't know
thank
what that
Oh,
you.
thank you.
Thank you, Dane. Anne Marie McKay, Laguna Beach's elected city clerk. I just want to clarify to see if I'm doing something right or wrong. I posted it in the chat, but for those that didn't see it, the increase that was approved for the Levine Act from 250 to 500, the way I read it is it starts in 2025. So our candidates that including myself that were in the general election for 2024, our council members still have to disclose and recuse themselves if they received over $250 for 12 months from the 2024 general election, correct? Or
So
did that make sense?
I'll step in here. I would definitely check with your agency council and their interpretation on this. My reading is as of January 21st, those new provisions go in. So the law that's in effect at that time when that matter comes before the agency would be the law in effect at that time. So depending on when this item's coming to council or coming before the decision-making body, that would be, you would look at the law that's in effect at the time.
That would be wonderful. So yeah, I'll talk to my city.
But yeah,
attorney.
confirm with your agency council because they may disagree. This is all new, so.
Right. All right. Thank you.
We have another question about the new rules on emergency teleconference attendance, especially the number of meetings per month. Any thoughts on whether you should choose based on how many regular meetings you have officially scheduled on the books or how many meetings are typically held, including special meetings per month? I don't have a thought on that. I don't know, Mark Newmanville, if you're still on the call, if you might have a thought on that. I know that Mark has looked at that legislation. We don't do teleconference attendance here in Chula Vista, so I haven't had to deal with that in depth. And if Mark isn't popping up on here, Clementine, you might either reach out to Mark or check with other agencies. Oh, there's
he's
Mark.
here, Carrie. Yeah.
Thank you.
The question about keeping track of the number of times for remote participation.
Well, there's the new, like the maximum depends on how many meetings you have per month, but I'm not sure how to interpret that because we have 2 regular meetings per month, but 10 months out of the year, we also hold a special meeting like on a regular schedule, even though it's not anywhere officially recorded as like a schedule, we do it. So we do have an average of at least getting close to 3 meetings per month.
Well, the code section says if the legislative body regularly meets once per month, twice per month, 3 times or more per month. It's funny that it doesn't say regular meeting. It just says that legislative body regularly meets X number of times per month. So, because the Brown Act certainly knows the difference between a regular meeting and a special meeting, and they didn't use the term regular meeting. So if you regularly have 2 regular meetings and 1 special study session a month, then I would say that your council regularly meets 3 times a month.
Okay, that's kind of how I saw it too. I just wasn't sure what other people might think. Thank you.
Yeah,
And
it
you
says,
know,
it says here, oh, sorry, go ahead, Mark, sorry.
I was just saying that's how I interpret it, but you might want to check with your city attorney.
Yeah, and you know, in the description here, it says the bill for purposes of counting meetings attended by teleconference defines, quote, a meeting as any number of meetings of the legislative body or of a local agency that begin on the same calendar day. So I think they may be looking at this like a you know, essentially a regular, you know, a regular meeting. But again, definitely probably, you know, want to talk to your counsel on that to get clarity, your legal counsel.
Thank you.
Thank you. We also have a question about AB 2904. Does it apply to both council meetings and to planning commission meetings? Megan, I don't know if you have
The
confirmed thought on
text
that.
of the legislation just specifies planning commission meetings.
And I have seen there's been some conflicting information, it looks like, going around on listserv, or that a law firm had put out information saying that it applied to both planning commission and to city council. So, we'd always encourage you to check with your own legal counsel as well. But that's how I read it as well, is that it just applied to planning commission meetings. For 1785, is it okay to post the address or APN if the elected official's name isn't linked to it? Crystal, I'd have to look into that a little bit more in depth, unless Megan, you happen to know on the bill about not posting the APN on the website, if you're okay to post it if it isn't linked to that person's name. I can't tell from reading the bill or from reading the text of the legislation quickly, so I don't want to say one way or the other.
Yeah, and I don't know, actually, I was wondering if Dane had context in that as to what the intention was behind the bill, because it did seem to imply that like the problem was that you could connect an APN to an address to identify someone. So I guess the question would be like, what things are posted along with that APN, and could those potentially identify that official?
So the intent was all about it was quote, closing a loophole to identify the person. And so I can tell you the intent was just to try and hide or try to keep the name of the official withheld with respect to sort of that next step of, well, if that APN is actually in conjunction with that elected official's identity, I would have to kick it back to the attorneys. But I know the intent of it was really all about trying to protect the personal information of a public official.
And one of the things we talked about amongst ourselves was the fact that it's easy enough to identify the APNs of your own elected officials in your jurisdiction, right? And theoretically, you can flag those, but there may be elected officials theoretically from other like larger jurisdictions that are still within yours that may be living in your jurisdiction. And how do you identify those people and know that? So it sounds like there are still some definitely unanswered questions about how people would implement this.
Okay, I think that I've got to all of the questions in the chat. Any other burning questions? Feel free to raise your hand or drop them in the chat. If there aren't any, I just wanted to thank you all for joining us today. I hope that you found this helpful. A huge thank you to Dane, Ethan, and Megan. I hope that you got a lot out of this session. We will post the recording of the session, the PowerPoint presentation, and all the additional materials on CCAC's website under legislative updates. If you check in the chat, I posted the link to that. We plan to offer this as an annual webinar going forward, and we'd love to hear your feedback. If you liked it, if you didn't like it, if you found it useful, if there was something else that we could have done that would make it more useful, please feel free to reach out to me, because we definitely want to make sure that it's a good use of your time. And then looking forward, our PPG is going to be presenting at the CCAC annual conference. I saw that conference registration opened up, so go ahead and register for the conference if you haven't done that already. We're also working on some additional webinar updates during the year, like probably summer and then in the fall, so that you can be kind of ahead of the game on what's going on with legislation, and you'll know ahead of the time what's coming forward. And then we're also working on a workshop that will be related to the legislative process and regulatory research skill development. The dates haven't been solidified yet. That one's probably going to be October-ish. But once we have those dates solidified, we'll make sure to let you all know so that you can join us for those. So I hope you found this helpful. I enjoyed seeing you all this morning. Dane, Megan, Ethan, any parting thoughts?
I think they've heard my voice enough today, so thank you all.
Thank you, everyone. And I did see some questions in there about the forms that like Carrie's examples. And I think, and correct me if I'm wrong, Carrie, but Carrie, we are going to post versions of those forms, the sample templates, like the letters and stuff like that, that you can use.
Yes, the Livinac samples that we put together, those will be part of the additional materials. So, and don't forget on the PowerPoint presentation, when you look at it, that there are additional bills that we didn't cover in the presentation to save time, and they may not be as relevant as some others, but you can go through those as well to see what else happened in the last year.
Can we
Thank
get can we get a copy of the chat? Because a lot of there's some URLs and other information in there.
I will try to make that available. We'll send out an email to all of the attendees with the link, and I'll make sure to include the link to where you can find the additional materials and all of that.
Great, thank you.
Yeah, you're welcome. All right, thank you for joining us today. Have a good rest of your day.
Thank you.